right, on the State versus Jonathan Strickler, these are your, we have a motion to reduce bail, a motion to, for a bill of particulars, and then a motion to quash subpoena. Is the state ready on those motions?
Yes, Your Honor. State ready on the motion to quash.
All right.
Your Honor, the defense has filed a motion to for a bond reduction hearing. And in doing so, the defense has subpoenaed the two minor victims in this case, along with the mother of those two minor victims. My motion to quash only goes to the minor victims, Your Honor. It's the state's position that there is no relevant reason that these minor victims should be required to testify at a bond reduction hearing for this defendant. Released to the defendant all the discovery in this matter. They have copies of the CAC reviews, of the forensic interviews of these two minor children, of their allegations of what happened. He also has the written reports done out by the CAC of those forensic interviews. So he knows what the allegations are, what the allegations are alleged. Plus, I have subpoenaed myself, Officer Rick Gordon, Senior, to come here and testify to the sufficiency of the evidence during this bond hearing. I would also argue that subpoenaing these minor victims and requiring them to testify is only, I would argue, is a form of intimidation towards these two minor victims on the part of the defendant, which will violate the Victims' Rights Act, Your Honor. That being said, I think these subpoenas should be quashed as far as to Vera Kirkland and Beta Kreider, and they should not be allowed to testify for this bond reduction hearing. Thank you.
Mr. Taylor?
Your Honor, we have seen these victims and their mother because we want to present evidence related to the likelihood of conviction, which is a consideration in any bond hearing. And my client, well, I've watched the videos, and this case seems to be based almost solely on the statement of one of those children. And as far as quashing a subpoena can be quashed if it is unsupported by material or admissible evidence. Well, in this case, that's not the situation. This is absolutely material evidence. It is admissible. It is the testimony of the alleged victim, and the entire case is almost solely based on it. That is, I would cite the court to State v. Johnson, 538 Southwest 3rd, 32, 2017. That's an instance or a case in which A.J. Johnson, who was a football player at the University of Tennessee, was charged with raping a girl at a party. And
I'm familiar with that case. I have recently dealt with this very issue in another case over in Dixon County, in which the same issue was raised. That Johnson case, my recollection is that they issued a subpoena for the telephones or the portable phones, the cell phones of the victims in the case.
Yes.
And that the judge, the learned judge who issued the opinion in that, said that certainly that information could be potentially relevant, and that certainly it is, usual that people were in this day and age, especially younger people, are hardly without their phones. That's a far different cry, is it not, than having the actual victims in an alleged rape of a child case brought into court to testify at a bond hearing?
Judge, again, if it's oppressive in that they're going to have to get information that they have to bring in, and it's somehow or another going to be difficult or almost impossible for them to do that. So I would say that motions to quash are generally done in situations where it's a subpoena ducis tecum, where they're being asked to produce a lot of things. In this case, all we're asking is that they come here. They live in Stewart, Tennessee, and they just come in and testify. Additionally, if a subpoena is unreasonable or oppressive, if it's an abuse process, something of that nature, then it could be quashed. Also, my client has a right to present a defense, and it's recognized as a fundamental constitutional right. I'd cite the Court of State v. Brown, 29 Southwest 3rd, 427. The right includes various entitlements, such as the right to testify in one's own behalf, which has been acknowledged as fundamental under both state and federal constitutions. Additionally, the right to present a defense encompasses a right to offer testimony from witnesses, and if necessary, to compel their attendance at trial. That is a constitutional right that the defendant has. Bring witnesses in, and in fact, in the recitation of the rights that the court does every time someone enters a plea, of course, the court says you have a right to subpoena witnesses to be brought in on your behalf, and the state will make them, or the court will make them come in here. Because you have a right to present your side of the story, which is really the crux of the right to present a defense, is the defendant has the right to get his story out. And in this case, if he's not going to be able to testify, then he has to be able to call the people in who are going to be the almost sole basis of the proof in the case. So I think the likelihood of conviction, no better way to determine that than to hear from the actual alleged victims and what they say happened.
Well, the state of Tennessee treats minor victims of sexual abuse differently than they do the regular witness. While Mr. Taylor makes an argument that clearly might apply if the victims were adults, this court finds that the laws of the state of Tennessee and the Tennessee Code in particular provides that there are differences to be dealt with in minor victims of child sexual abuse. For example, in 24-117 of the Tennessee Code, it sets forth a method by which the testimony of a child in a sexual abuse proceeding can be audiovisually recorded rather than having to have the child come into court and testify in person. But more importantly, the admission of video recording of an interview with a child, the system is set up to try to minimize the number of times that a child, alleged victim of sexual abuse, is traumatized, if you want to use that term, by having to come into court and testify. And for that reason, even in a trial where the question is not whether or not to set a bond or how much the bond should be, but rather the proof beyond a reasonable doubt that the state would have to prove, there is a method by which the state is allowed to use a videotape interview with a child, which is usually referred to. That can come in as substantive evidence for the child. Now, it does require that the child be present and subject to cross-examination, but that is a procedure that is designed to minimize the number of times that a child who is alleged to be the victim of sexual abuse is required to come into court and testify and be subject to cross-examination. Whether that's fair or unfair, it is not this court's position to say, but I'm saying that that's, in my opinion, a policy that our state legislature has adopted. So if it is that important for a trial on the merits beyond a reasonable doubt, that we protect a child from having to be multiple times testify, then having a child testify, a child victim of sexual abuse brought in under a subpoena and testify at a bond reduction hearing violates, in my opinion, the victim's rights statute that the state of Tennessee has adopted. It also runs counter and contrary to the statutes that provide for the admission of video recordings and interviews of the child. At a bond hearing, certainly, if the defense wishes to rely upon what the children have said as being the strength of the case, then that video is available to be brought in and used as a part of that proceeding on the bond issue. But subpoenaing the actual physical child to come in and testify, in my opinion, runs counter to the purposes of this. And I believe that it also rises to the level where in the Dixon County case that I had to issue a written opinion about, in that particular case, the defense had issued a subpoena for all of the electronic recording, every electronic device that these two young women had in their family, any of the cell phones, electronic devices, all computers and everything, to be turned over to the defense expert and let that expert take them apart if necessary to determine. And after considering that hearing and looking at the case law, I ruled that the Johnson case may have applied in that particular situation, but that the state does have an interest in some instances, and that there was Tennessee case law to support that, and case law cited by other jurisdictions, that there are occasions when the state has a legitimate interest in seeking to quash a subpoena, and that is oftentimes or will arise where it's the victim that is being subpoenaed, and they're wanting to make that victim bring in certain information. Even more important would be the state's interest in protecting a victim in a child rape case from having to be brought in and subject to cross-examination at a hearing on a bond issue. So because there are other methods by which the strength of the case can be demonstrated, such as the forensic interview, it is this court's opinion that the state's motion to quash the subpoena for the two minor victims should be granted, and therefore it is granted. So,
Thank you, Your Honor.
now, having said that, does that affect your motion? Do you wish to rethink your motion so that you can produce that forensic interview for?
No, Judge, I'll go ahead with the bond motion. And we haven't really talked about the motion to bill particulars. I don't know if we'll be able to agree on something on that.
Yeah.
We'll talk about that. So if you could just pass that motion.
Look, we can do that.
And I'd call Jessica Kreider.
Oh, Jessica Crowder.
This is on the bond motion.
Yeah. Ma'am, if you'll come right up here, please. Raise your right hand. Face our clerk.
You solemnly swear or affirm the testimony about to give me the truth, whole truth, and nothing but the truth, so help you God.
You'll come around and have a seat in the witness stand. You may proceed.
What's your name?
Ms. Crowder, if you'll come, move closer to that microphone, so
Yes,
we're recording the phone. So.
And where do you live?
Stewart County,
What address? And where do you work?
Stewart County Sheriff's Office,
And how long do you work there?
since the end of April.
You had a relationship with Jonathan Strickler, is that right? And how long was that relationship you had with him?
About 4 years over a 5-year period.
Okay. And did you always live here in Tennessee or somewhere else?
Always in Tennessee.
And where did you live in Tennessee? What addresses?
At my current address and in Houston County.
Okay. And your current address, when did you move into that address?
The first time and the second time
First time.
in 2019.
And you know about what time of year?
It's May 24th, 2019.
And that was in Stewart County. And how many children do you have?
4.
And what are their names?
Beta, Vera, Isabella, and
I didn't hear the last one.
Haley.
And are any of those children Mr. Strickler's children?
Yes,
How many?
1.
And which one?
Haley.
And so you moved into the Stewart County address 52419. And how long did you live there? When did you move out?
I've lived there except for 1 year.
Okay. And what year was that?
Between 2022 and 2023.
Do you remember the dates when you moved in and when you
It
moved out?
was June 22 to July 23. I don't remember the exact date.
So it was sometime in June,
So
but you don't know what day,
I remember looking around the middle of June.
or sometime in July.
It was like the second week of July.
And other than that, you lived in Stewart County.
Yes.
And at some point, when you lived in Stewart County, you had some involvement with the Department of Children's Services regarding your children. Is that right?
Yes.
When did you first have an occasion to have the Department of Children's Service investigate something with regard to your children?
2013 or 2014.
2014. And what was the investigation regarding?
The very first investigation I ever had was over my second daughter and a 3rd-degree sunburn,
What is her name?
Vera.
And that's the daughter, that's your child that's here with you today, one of them. And that was the first involvement with DCS
Yes.
over a sunburn. What was the second time?
The next 9 were about Isabella.
The next 9?
Yes, her father called religiously.
Isabella. And what did that have to do with?
Anything and everything. I'm not exactly sure.
Okay. Did
There
it
were
have,
multiple ones.
okay. Are you familiar with a person named Jaden Wallace?
Yes, my nephew.
And was there an allegation at some point that Jaden Wallace had sexually molested or touched your children?
Yes.
And that was prior to these charges. Is that right? When did that happen?
2021.
And there was an investigation conducted regarding that. And what was the determination of that investigation?
I don't exactly remember, but it went something along the lines of, don't let my children be alone with him, just on a cautionary side.
But it was unfounded. Isn't that right?
I believe so. I don't remember, I'm sorry.
So in other words, the allegations that were made against Jaden Wallace were determined to not be correct or true.
That's not the case, no. I believe they didn't have enough to say whether it was a yes or no.
Okay. And were your children interviewed by the Child Advocacy Center
Yes,
for that particular instance in
Yes.
21? How many times have your children been interviewed by the Child Advocacy Center?
like 4 or 5.
And when was the first time that they were interviewed?
I believe in 2021.
And which of your children were interviewed?
Vera, Veda, Nesbo.
All right. And did you ever see those videos?
No,
When was the next time that your children were interviewed by the Child Advocacy Center?
2024.
And was that regarding this instance? How many of your children or which of your children were interviewed regarding to this instance?
All 3 of the older ones.
All 3 of the older ones, which are
Vera, Veda, and Isabella.
Vera, Veda, and Isabella. And so you had a relationship with Mr. Strickler. I think, did you say it started in 2019?
Yes,
And y'all lived together for a period of time, and he was living here in Tennessee, right? And how long has he lived in Tennessee?
I'm not actually sure.
Is he from here originally?
No,
Where is he from?
Nevada.
And how long did he live in Nevada, do you know?
I don't.
Where did he live here in Tennessee?
When I met him, he was living with a friend
Where at?
in Clarksville.
So he lived in Clarksville for a period of time. And then he moved in with you. And at some point, you're saying he moved to Eram.
Yes,
Where did you live here in Eram?
on Elm Street.
On Elm Street? Okay. Okay. With regard to my client, not the other allegations regarding the Child Advocacy Center, how did you come to suspect that my client had done something with regard to your child?
My niece said that something had happened to her. And so that raised a question with me and my children. So I pulled them aside one by one to talk to them.
Okay, so your niece, what is your niece's name?
Lydia,
And Lydia, what? Her last name?
Kreider,
And how old is she?
4.
And she told somebody that somebody had touched her, right?
Yes,
But she didn't say who.
she did.
She said some mean man touched her.
I'm not exactly sure how it all started. I just know where it started on my end with my children.
Okay, so your niece told her mother,
I believe her dad's girlfriend.
her dad's girlfriend. And then your dad's girlfriend came and told you that Lydia said somebody,
Like my sister and the girlfriend and the father, they all called me and said they had something concerning to say. I'm not exactly sure what happened with my niece and with her parents. I only know what happened with my children when I spoke to them.
okay, and you don't know if Lydia was interviewed by
She was.
she was, and they determined that they weren't going to proceed
not.
with anything,
I'm
correct?
not sure because she's not my child. They didn't speak to me about it.
Okay. But nothing ever happened with regard to criminal charges or anything like that with regard to Lydia Crider, did they?
I don't believe so.
Okay. So you got this allegation from these three people and you went
I asked my children.
how did you do that?
I brought them in a room one by one
Okay.
to ask them individually with no one else around.
Okay. And you asked him if he had done anything to them.
Yes.
Is that right?
Yes.
And did you discuss with them what potentially would have happened?
I'm sorry, I don't understand.
Did you tell them that he supposedly touched them?
Did I tell them that he did? No.
Yeah. Well, what did you ask
No,
him?
I took them, brought them to a room by themselves and asked them individually if he had ever touched them. I asked them point blank, did this person specifically ever do anything inappropriate?
Okay.
Did they touch you anywhere that is a no-no area, anywhere in inappropriate places?
Okay. And what did if you would go one by one on the children, what did they each say?
At first, Beta did not talk to me about it. She still hasn't really spoke to me about it. Vera said yes, and Bella said no.
What did Vera say?
She just said yes.
Said, yes, he touched me.
She didn't give me specifics. So that raised questions to what do I do next and how do I figure out what really happened?
Okay. And what happened?
At this point, I'm not really sure. They don't talk to me about it. I don't question them about it. I have personal traumas of my own in that area. So it's not something that I don't want to pressure them because I don't want to make them feel unsafe. But at the same time, I would like to know.
Did you go to the police?
I did not. The
Okay.
police came to me.
Okay. You said you would like to know. But
I mean-
so you don't really know, or you don't really know one way or the other, do you?
I only know what was said. And what was said that, yes, something did happen. As far as the specifics, I don't know.
You don't really know what happened.
I would like to know.
Was any kind of medical examination ever conducted with regard to your children?
No.
They were never,
I took them to the doctor. The doctor said that they're not the ones that do those specific, they're regular PCP. They said they don't do those specific kind of examinations. I talked to the Child Advocacy Center and the DCS office, and they said that they wanted to interview them before proceeding with an examination.
so they said they wanted to interview the children before a medical examination was
Yes.
conducted on them?
Yes.
So no medical examination was ever conducted? Do you know if there's any kind of DNA evidence or anything like that with regard to this case?
No.
Is there any kind of video or audio of anything that is alleged to have happened?
I'm not sure.
Do you have any idea where exactly this happened?
An earring.
How do you know it was an Aaron?
That's the one thing that I do know.
How do you know
Not
that?
because of my children, because someone else,
Someone else,
the officers in the case.
the officers?
The officers, the people that watched the interview, I was not allowed access to the interviews.
Okay, so you're relying on them watching the interview and, what was the layout of your house in Erin?
Walk in the front door and there's a living room and kitchen. Walk down a very tiny hallway, there's a bedroom. Keep going down the hallway, there's a small pantry in the hallway. Then there's a bathroom and one more bedroom.
Okay, and who slept in what bedroom?
In the very back bedroom, I slept there with Mr. Strickler and my 3-year-old. The 3 older girls slept in either in the living room or in the bunk bed in the little room in the middle.
Okay.
There was a period of time where I wasn't there. I wasn't sleeping there because I was working overnights.
Was there ever any kind of damage to the windows in that house?
Yes.
Can you explain what happened?
The very back bedroom, the dog jumped through the window and broke it.
And why did that dog jump through that window?
She's a dog.
Do you have any idea if there was somebody outside on a bicycle or something that the
I
dog?
don't remember. I just know that she jumped through the window and broke it.
Okay, so you don't have any idea. Why?
I mean, I'm sure at one point my brain had retention of the information, but at this point, I don't remember. I do know that the dog is the reason the window was broken.
All right, and when when the window was broken out, Mr. Strickler repaired that window right away, didn't he?
No, didn't do anything right away.
Hey, did he repair the window?
It took some time, but it was repaired.
How long?
I don't remember.
1 day, 2 days, a week, a month,
I mean, a few days.
a few days? How did he repair it? What did he put on it?
I don't remember.
Was it secured, closed?
Nothing in that house was secured.
Okay. Your child, Vera, she has some developmental delays. Is that right?
She has something. She learns a little slower than others.
Okay. Does she have any kind of diagnosis?
Just that she has a intellectual disability through school.
Okay. And does she have an IEP and
She does.
special education and
With an IEP.
okay. And do you have any idea what that is or what it's for?
It's just so that she can get more time to better understand what she's learning and how she's learning.
Okay.
She just learns slower than
So
others.
she has a hard time understanding things.
No, I think she actually understands things pretty well sometimes. I think it depends on what it is and how well it's explained.
Okay. So she potentially though would have trouble keeping up or
Sometimes.
and understanding the things that are going on around her.
Sometimes.
And specifically what somebody is telling her. Right?
I don't understand.
When somebody's talking to her, telling her things, it's sometimes harder for her to understand what's being said.
Maybe, yes.
Okay. And you took that into consideration when you were talking to her about Mr. Strickler potentially touching her?
I do.
Do you have any idea if the Child Advocacy Center took that into consideration?
I'm not sure.
You know, if Mr. Strickler, or was he ever employed while he lived with you?
Had a lot of jobs.
Okay. So he worked and
No. He had a lot of jobs.
he had a lot of jobs. Okay. Did you ever talk to Vera about, where she was when these things happened?
No.
You never asked her about that?
I wasn't allowed to.
You weren't allowed to?
No.
Who?
I was told that I was not allowed to question them about anything.
Okay. Do you have any idea when these things were happening with regard to Vera, where Veda was?
The only thing I know is that everything in regard to the question happened in the trailer. I don't know what time of day. I don't know where the children were. The only thing I know is I wasn't home when these happened.
The trailer in Stewart County?
No, in Erie.
So you live in a trailer in Stewart County?
No, I live in a house.
Okay, so it's a house there and a trailer here.
Yes.
I'll pass with this to you.
Woodall?
Yes, Sean. Ms. Kreider, correct?
Yes, sir.
I just have a few questions for you, okay? Now, you said you lived in a trailer in Houston County from the time frame of June 1st, 2022 to July 31st, 2023. Is that correct?
The middle of June to the beginning of July.
And where were you working during that time frame?
I worked at BDI and Suncrest,
So you had 2 jobs.
2 jobs.
Did Mr. Strickler have a job during that time frame?
I had 2 jobs, each of them for like 3 weeks.
3 weeks.
That's it.
Was the majority of the time, I mean, where were your kids when you would go to work?
At home.
Were they with the defendant?
It's
Does the defendant still have family in Nevada?
currently.
Apparently. Now, this situation with Jaden Wallace, is Jaden Wallace related to you?
My nephew.
Is your nephew? How old was Jaden at the time of the allegation?
11.
He was 11.
I do remember correctly.
So it was a juvenile on juvenile. We're here, we have an adult on it.
Yes.
Now you said your niece is it Lydia?
Lydia.
Lydia, right. She said something happened and she's 4. Who did she allege committed a sexual act on her?
The way I understand it, Mr. Strickland.
Mr. Strickland. That happened in Houston County?
Yes.
And who was living at the house or the trailer in Houston County during this time frame that y'all were living there?
I lived there with my 4 children. Mr. Strickler lived there. And my sister, my nephew, and my 2 nieces were in and out a lot.
Did your sister stay there?
She stayed there a lot.
Did she stay there during the day?
Sometimes. Most of the time she was gone during the day.
Who's your sister?
Catherine.
Catherine Kreider?
Yes.
And has there been an ORCID's examination done on Veda or Vera?
I don't know what that is.
That's one, Sean.
Any other question?
No, Your Honor.
Thank you, ma'am. You may step down. You're free to leave, or you may have a seat in the courtroom, whatever you'd like. Taylor, you may call your next witness.
Call Ryan Goldsmith.
Raise your right hand, be placed under oath.
You solemnly swear or affirm the testimony you're about to give to be the truth, whole truth, and nothing but the truth, so help you God.
I do. Name?
Ryan Goldsmith. GOLDSMITH.
And could you give the court a little background on your experience and training as it relates to investigation?
Sure. I'm currently employed as a 23rd Judicial District Public Defender Investigator. My law enforcement career began in 1992. I served over 21 years as a U.S. Army Military Police officer. I've completed basic, advanced, and senior military police training. In 2013, I was hired by the Stewart County Sheriff's Office as a deputy sheriff. I'm a graduate of the Tennessee Law Enforcement Training Academy. I worked for 6 years at Stewart County Sheriff's Office, patrol deputy, patrol commander, general department instructor. I'm certified as a law enforcement training instructor through the state of Tennessee.
Okay. And at my request, did you conduct an investigation into my client's criminal history and background?
I did. I queried the NCIC, the National Crime Information Center, for a criminal history check, and also used our investigative database through Westlaw to obtain a criminal history on it.
Okay. And what did you discover?
I discovered a conviction for driving without a chauffeur's license, typically referred to as driving without a license, in Tennessee in 2020, along with no insurance.
Okay. And does he have any kind of felony convictions?
I did not find any in those two databases I queried.
Has he ever failed to appear in court? Does that show up in his record?
I saw no arrests or convictions for failure to appear.
And he's lived in what locations? Central Nevada and Tennessee?
The background check that I ran showed addresses in Montgomery, Stewart, and Houston County from 2018 until 2023. And then I returned back to Nevada, and prior to that, it showed addresses in Nevada.
Nothing from the good.
Other questions, John?
Thank you, sir. You may stand down. Toby, you may call your next witness. Since has rested your proof, do you wish to offer any proof?
Yes, sir. I will call Officer Rick Warren to take briefly on.
All right.
You solemnly swear or affirm the testimony you're about to give the truth, whole truth, and nothing but the truth, so help you God.
Please state your name for the record.
I'm Rick Gordon, Assistant Chief here in the Police Department.
Okay. And how did you get involved in this case?
I was contacted by DCS and the Child Advocacy from the Dover office after they did a forensic interview of Vera Kirkland. They thought they had a case that was going to be in the Stewart County jurisdiction. It turned out to be in the Houston County jurisdiction.
Now, are you familiar with the house that these two minor victims lived in and the defendant lived in?
In here, yes, sir.
How are you familiar with this house?
We had, I believe, two occasions. Number one is located close to the police department to start with. They had a couple of big dogs that continually got out. I spoke with the defendant on at least two occasions about his dogs, actually helped him look for his dogs one day. And then had to return back to the home and cited the individual for dogs at large because they continued to get out.
Now, was there an incident where the dog got out of the window and damaged the window of the house?
According to the defendant, yes. So the dog actually jumped through the window. He said he had trouble keeping them up. They're so big, and then one of them was so aggressive to get out of the house. He actually went through the window.
Now, have you reviewed the forensic interviews of these two minor victims?
Yes.
Does one of the minor victims reference that window being broken?
Yes.
Your Honor, I will object to hearsay.
Hearsay statement regarding the child's statement regarding the window.
I'll move on, Your Honor.
Sustain the objection.
You said you did review the forensic interviews, is that correct?
Yes.
Was that one of your bases for charging the defendant?
Yes.
Now, does the defendant have family in Nevada?
He does.
What kind of family does he have in Nevada?
I believe it's his mother. I'm not sure about, extended family.
Was there any concerns regarding your department on Mr. Strickler leaving the state and going to Nevada?
At the time of the indictment, he was in Nevada.
He was in Nevada?
Yes.
How long was he in Nevada for?
I'm not 100% sure how long he'd been in Nevada. He returned back to Tennessee shortly after.
Do you know if there's been an ORCID's evaluation on these two victims?
I don't believe so.
That's what it's your.
Taylor, you may cross-examine.
As part of your investigation, did you interview Jessica Crider?
Yes, we did.
And did you interview Vera Kirkland?
I did not.
Beta Crider?
I did not.
When, well, where did you arrest my client? Where did you arrest Mr. Strickler?
I'm sorry, I couldn't.
Clarksville.
And so you went up to Clarksville and arrested him where he was living there?
Yes, sir.
Okay. And did you transport him back to Houston County?
Yes, I did.
Did you interview him during that drive back?
No, we talked, yes, sir.
Do you have a recording of that conversation?
Yes.
Did you, once you got back to Houston County, did you conduct an interview with my client then?
Yes, sir.
And where did that interview take place?
At the Houston County Sheriff's Office.
And who was present for the interview?
Myself and Chief Moore, I believe.
Okay. And about how long did that interview take?
I think, if I recall correctly, about 30 minutes or so, maybe a little longer.
All right.
I'd have to look at the tape to remember the exact time.
Okay. And so there is an audio and video recording of that also.
Yes, sir.
Okay. And he made no admission whatsoever during that, did he?
To what, sir?
Admission to these charges, of these allegations.
Not admission to the rape of a child, if that's what you're asking.
Yes, that's no. Well, what did he make an admission to then? If you
There's occasions where he had to apply medication he claimed to the vaginal area of the children.
okay, so he had to give them medical treatment or something like
Yes.
that. Okay. You don't have any idea, or you have no criminal history on my client. Is that right? He doesn't have any real criminal history, does he?
No, sir. Same criminal history that your investigator found is the same criminal history that I have.
Okay. And he's lived essentially in Nevada and in Tennessee.
Yes.
And he was back here in Tennessee when you arrested him from Nevada.
That's correct.
I'll pass it with you.
Read it right.
No further questions, John.
Thank you, sir. You may stand down, have a seat in the courtroom if you'd like. They may call your next witness.
Doesn't it states approved?
State has rested their proof, Mr. Taylor. You have a rebuttal proof?
No, sir.
I'll hear you an argument.
Your Honor,
Current bond is $500,000.
it is $500,000, Judge, and my client, there is no way he can make a $500,000 bond. I think based on the proof, he has no criminal history. He's never failed to appear in court. He is being held on this bond based on an allegation made by a child during an interview, and we really don't have any information on what that that allegation actually was at this hearing. So I would say that the likelihood of conviction is low, and that he should not have a bond or have to set him in jail with a $500,000 bond just based on a mere allegation by a child that was made in a forensic interview where we don't even know if the interviewer knew that this child had developmental delays or other issues that would cause her problems in understanding what they were asking. So, based on that, I would ask the court to reduce his bond, set it at a total of $10,000.
Woodall?
Your Honor, the state argues that this defendant has been charged with 3 counts of rape of the child, 2 counts of attempted rape of the child. There are 2 victims in this case, Your Honor, not just one. State would argue that the bonds are appropriate in this matter. The defendant does have access or has family in Nevada to go to. If he is bonded out, he was actually in Nevada at some point during this investigation. So the likelihood of him, there is a likelihood that he could, if he reduces bond and he makes it out, go to Nevada and we'll come back to Tennessee. That is a issue. I would argue that's one of the reasons that the bond is the way it is, plus the seriousness of the offense. So based on that, the state would argue that the bond is appropriate and should remain the same.
Mr. Taylor, anything else?
No, Your Honor.
Anytime the court is required to consider the amount of a bond or setting a bond, I'm required to consider the factors that are set forth in our Tennessee code. And those factors are found in TCA 40-11-118. And basically it says that in determining the amount of bond necessary to reasonably assure the appearance of the defendant while at the same time protecting the safety of the public, the magistrate shall consider the following. 1, the defendant's length of residence in the community. The defendant doesn't presently reside in Houston County or in this community, although my understanding is that he had, has previously lived here for a short time, but was living in Clarksville. Even if you argue Clarksville is a part of the community, I don't think many people in Houston County considered Clarksville, Montgomery County to be a part of their community here. At least I didn't when I lived here. So the defendant's employment status and history and financial condition, I have no information that he's working anywhere. Ms. Crowder indicated that while they were together that he had lots of jobs, but he wasn't really working steadily. So I don't have any information about his financial condition. Family ties and relationships. The only thing I've heard about that is that his mother lives in Nevada. The defendant's reputation, character, and mental condition. Don't have any evidence about that. The defendant's prior criminal record of appearance at court proceedings, record of flight to avoid prosecution, or failure to appear at a court proceeding. The record that has been introduced at this point in time by Mr. Goldsmith is that there was no, I think it's not converted, it's not disputed that his only record was that he had a misdemeanor driving charge of some kind. So there's no extensive criminal record. The nature of the offense and apparent probability of conviction and the likely sentence. He is charged in counts 1, 2, and 3 with Class A felonies. In counts 4 and 5, he is charged with Class B felonies. Because there are multiple victims, the possible sentence could be an extensive and long sentence in prison if, in fact, he were convicted. And a high likelihood, the likelihood of conviction, while the defense argues that the only thing that is holding him in jail under a $500 bond is the fact that a statement of a child, that's often the case. Unfortunately, that sometimes that's the only evidence that you have in these kinds of cases. So it will be up to a jury to determine whether or not that constitutes proof beyond a reasonable doubt under all of the circumstances. But the court does credit what was brought out by the officer's testimony that during his interview with Officer Gordon, that he made the statement that he applied ointment or medication to the vaginal areas of these children. I find that to be something that a jury may find highly suspicious, and it may be that evidence and that admission, coupled with the statements of the child, may be sufficient to prove beyond a reasonable doubt. It certainly is something that a gentleman living in a relationship with a woman who has children that are not his, that I can't believe that would be a reasonable thing for him to consider, that he could apply medication to the vaginal area of female children that were not his children, and that would, especially when they were these ages, and that would be an acceptable behavior on his part. That being the case, it goes to the issue of whether or not there's a likelihood of conviction. So it may not be the strongest case in the world from what I've heard thus far, but there is evidence that a jury could potentially find that he is guilty of these offenses. And if found guilty, he would be facing a substantial, possibly the rest of his life in prison. Because there are multiple victims, it's my understanding, and it is a sexual abuse type situation, it may be that could be consecutive sentencing. The identity of responsible members of the community to vouch for his reliability. No one came to court to testify for him. Any other factors indicating the defendant's ties to the community bearing on the risk of his willful failure to appear. The fact that he has those. The fact that he was living in Nevada at one point after his relationship with Miss Crowder and then returned to the state of Tennessee shows that he has pretty much a mobile lifestyle, and that he does have family outside of the state of Tennessee. His ties are very tenuous to the state. So based upon all of those facts, the court is of the opinion that there is a substantial need, or a need for a substantial bond. A $500,000 bond, and by the way, the state legislature, it's my understanding, did pass the bill that says it's going to eliminate, I think, as of July 1, the consideration of whether or not someone can make that bond. The financial ability to make a bond, I think, is under the new law going to be eliminated. So it's not going to be even matter whether a person can or cannot afford a bond. That's not even going to be a factor that the court can consider. But in any event, this court is of the opinion that the bond of $500,000 is excessive based upon the fact that there is some question about it, and I set the bond at $250,000. If he makes the bond, he will be required to have a GPS monitoring device. He will be required to reside within the state of Tennessee, and he would have no contact whatsoever with any minor children, period, as a condition of his bond. It doesn't mean just the minor children involved in this case. He will have no contact with any minor children at this point. So, all right.
Yeah.
All right, we will take our noon recess until 1:15.
All right.